Reputational harm and mental anguish can seem like abstract legal terms. How do you exactly prove reputational harm, intentional infliction of emotional distress, mental anguish, pain and suffering, and other types of harms in a legal battle? Having strong evidence can make or break your defamation case. I'm Sarah Kolick, an attorney at Minc, and today I'll guide you through how to properly attempt to prove damages in a defamation case. These types of intangible harms are often claimed in lawsuits as damages. Without damages, you might not have a case at all, or even if you do have a case, you might not get a big enough award to cover attorney's fees, the cost of filing the suit. So damages is part of the elements for a claim for defamation, and it needs to be proven with evidence for the legal action to proceed in cases where the allegations are not defamatory per se, that is, defamatory without need to show that you were damaged. But for other types of statements, false statements published online or elsewhere, you do as a plaintiff need to prove damages. So let's start with the basic elements of defamation. These are the basic 5 elements you need to successfully state a claim for defamation under the laws of most states. First, you need to have a false statement of fact. You must demonstrate that the statement is objectively false and is not an opinion. And remember, truth is an absolute defense to defamation, meaning that is protected speech. So the second element is that the statement has to be published to a third party, which is usually easy to prove if something is published online. Our niche here at Minc is working exclusively with online defamation, but these days that's mostly everything since we're living in the digital age. The defendant has to be the one that publishes the false statement of fact to a person besides yourself. Third element is that the statement has to identify you or your business, either directly or indirectly. The average Joe, the average person online has to know that you're the one that the defendant is talking about. The next element is false. Now in defamation law, there's 2 general categories. We have public figures, and there's subcategories, of course, because we're lawyers and we have to make everything complicated. And there's also private figures. So most of us are going to fall into the category of private figures. We're just ordinary people. We're not household names. We're just going about our life. So us private figures need to show negligence. In legalese, this means that our defendant did not take reasonable care to check for the truth. Now, for celebrities and household names, people that we know, politicians, anyone who holds an elected office, they're considered public figures. And in the United States, a public figure needs to prove actual malice. That means that as a plaintiff's attorney, that I have to look into the mind of my defendant to prove that they knew what they published were false, or that they were so reckless in their disregard for the truth that no reasonable person could possibly believe that what they had published was true. The plaintiff suing a news company, a news organization, generally also has to meet the actual malice standard. And lastly, damages. This is where we're going to spend most of our time today, despite my rattling on earlier. So you have to show tangible harm to your reputation or emotional distress, generally to have a claim for defamation. So how do we do this? I cannot overstate how important it is to collect evidence of defamation right away. The internet moves fast and people can edit and remove statements even when the harm has already been inflicted. Capturing screenshots of every defamatory statement and save the URLs. Be sure to include the username of the person who posted online, what platform it was posted on, when the post was made with timestamps, and any relevant interactions to it. We also want to show how prevalent this statement is and how it's affecting the public's views of you. So saving comments, number of people who have liked the post, how frequently the post is shared, where it's been shared, so can all be helpful in documenting a case for defamation. Equally important is the documentation of financial losses and emotional distress. You know, if I have a client who has customers that are basing their purchasing decisions off that statement, that's very strong evidence that the defamatory statements caused them to lose a sale, that's having a documented financial impact. Similarly, if you're fired from a job because your employer believes false statements that were published online, it's a pretty clear-cut case that the statements are causing you damages, financial harm. Maintain detailed records of bank statements, invoices, and correspondence with clients, particularly clients that are asking you about the statement. Now, if you've gone to therapy or counseling, retain a record of appointments, diagnoses, treatments to substantiate the emotional toll. Look into how the false statements may have affected your visibility on social media and standing within your professional circles. Sometimes defamation can be both extremely public and cause a lot of conversations about you, and sometimes it can feel like you're being iced out. Have your views, followers, engagements gone down? Have you been removed from groups or events? Now, I would like to say that there's also, again, that category of statements that are defamatory per se, where you don't need to prove damages as an element of defamation. It's easier for a juror to comprehend if you have a list of damages, something that they can conceptualize when making that monetary award. Collect as much data to support what changes are happening around you since the defamatory statements were published. Now, addressing emotional distress requires careful documentation as well. You can keep a journal of anxiety, depression, mental health struggles stemming from the defamatory statements. How have your relationships been affected? How has it affected your ability to show up at work or social events? This level of detail is going to help build a strong case, but it's also important to acknowledge and validate the pain and suffering this is causing for you, and it can be a meaningful part of this process. So I want to take a moment to address the possibility of receiving serious personal threats, intent to bodily harm, and abuse online. Often defamation and violent personal threats can co-occur, and these are another very serious matter. Please remember to include any evidence of any abusive messages or intent to harm you, the people at your business or your loved ones. This can be escalated to a criminal matter. If you're in a life-threatening situation, you can always call 911 and go to ic3.gov to report serious threats of violence, stalking, or invasion of privacy. If at any time in this process you are struggling with thoughts of self-harm or suicide, call or text 988 right away or visit 988lifeline.org. Reaching out to people who care about you isn't just a resilience strategy for your mental health. It's also a good legal strategy, because after all, witness testimony can be strong support for your case with third-party perspectives on the harm you faced. Reach out to colleagues, clients, and industry peers who can attest to the damage of your reputation, and secure written statements or commitments to testify if the matter proceeds to trial. But be careful, if you publicize the defamatory statements to too many people, that may also cut against you, because the defendant's going to say, why is the plaintiff publicizing these statements if they're causing so much harm to their reputation? But again, mental health comes first even before your legal needs. You'd like to have expert testimony, so an independent expert, a therapist, a psychologist, psychiatrist, evaluate our clients to draft an expert report documenting the ways, in their professional opinion, that whatever was published or said online has adversely impacted our clients' emotional well-being. There are folks who specialize in assessing reputational repair campaigns and can provide an estimate, can give a dollar value to the amount of money they believe that you will be spending on repairing your online reputation. This can be admitted as evidence of damages in a defamation suit. In any tort or in any lawsuit, we have to prove that the defamatory statements cause the harm you're experiencing. Reputation expert can help establish this link. This can be a finance professional, expert in your field, healthcare provider like your therapist or counselor. Before a jury, they're going to take what your therapist or counselor says with a grain of salt as opposed to an independent expert. Their testimony can secure a strong case in your favor. So I want to emphasize here that any lawyer will tell you, don't talk about your case publicly. Anything you say can and will be held against you in court. It may be tempting to tell your story publicly or fight back, but if you're serious about filing a defamation suit, this could actually hurt your case. So early on during my client consults, I give my clients two options to combating defamation. The first is through filing a lawsuit, which is going to be a lengthy process and is going to require you to take a step back from discussing anything publicly. The second option is the remedy to bad speech is sometimes more speech. If you're someone who wants to share your side of the story, wants to be public in combating the statements, then maybe filing a defamation suit isn't the best option for you. Again, you want to make sure anything that you're publishing online doesn't get you into trouble for defamation, so it still may be helpful to consult with an attorney. Even if you file a lawsuit, it's still possible to speak publicly, but what you're going to put out there is going to be to a certain extent controlled by your attorney. And believe me, if you publish something that causes your attorney any concern for your case, you will be hearing about it. So again, think very hard before you decide to retain counsel, whether you want to speak publicly, whether that's more important for you to have your perspective out there and to be candid about what you're experiencing, or if you would like to entrust the court system to handle your matter. Coming from me as an attorney, I would never advise you, your loved one, or witnesses to talk about a case without consulting an attorney or PR professional. In the discovery process, you will likely be asked to produce records of any treatments that you receive. Even highly personal therapy notes will become part of the discovery exchanges as well. You have attorney-client privilege, so certain information won't be made public, but it will be shared with the defendant. Now, we can get protective orders in place, but again, if something proceeds to trial, anything that's submitted as an exhibit in trial may be subjected to the public record. It is possible to file certain documents under seal, but this can be extraordinarily complicated, especially when addressing issues relating to First Amendment freedoms. Remember that by filing a defamation suit, you are taking those allegations that have been published online that are hurtful to your reputation, making them part of the public docket. This can backfire in certain cases, as now you may have given more publicity to allegations that you want to go away, something that every plaintiff should be aware of before filing a suit for defamation. When something's published online that is defamatory and disparaging towards us or our business, our initial reaction is to catastrophize. We assume the worst, that people are no longer going to be purchasing from our business, that we're going to lose our job, that a whole parade of horribles is going to happen. And I think increasingly in our digital age, people are realizing that we all read things we see on Facebook, Twitter, TikTok, Google with a grain of salt. So before making the decision whether to pursue a lawsuit, it's important to actually look at the impact that the statement is having and to see if it's actually affecting your bottom line or day-to-day life. A lot of times, we make things out to be worse in our heads, and it's always good to see if we can back up our fears with empirical evidence. So you've done the brave work of collecting all the evidence. If you haven't retained an attorney yet, this would be the time to do so. If you believe you're being defamed, you can contact a lawyer right away who can help guide you through this evidence collection process. Preparing this evidence in advance can save you time and money, because remember, we all bill our time hourly. Bringing high quality and organized evidence to your first attorney consult can allow your attorney to get to work right away on finding legal remedies to your situation, and also giving you a fair assessment of what you can reasonably expect in terms of damages, costs, whether your defendant's collectible and you will be able to realize those damages. But a lot of times you're suing a person, if they don't have the money to cover $100,000 judgment, $1 million judgment, you're not going to get that $1 million judgment out of them. And of course, you're going to want to assess the claim's strengths and weaknesses. I know that this can be sensitive, embarrassing, or even triggering to discuss these topics critically. But it's your lawyer's job to be candid and to give a realistic assessment of what their thoughts are on the evidence and the opposing side's evidence, and how the evidence is likely to come across to a jury or a judge. You and your lawyer can identify any gaps and anticipate potential defenses from opposing parties. This balanced review will help prepare effective counter-arguments and guide your decisions on whether to pursue litigation, start settlement talks, or engage in alternative dispute resolutions, or even dismiss the matter altogether. Your lawyer should advocate for your strongest evidence that supports your claims and aims to repair your reputation throughout the process. When you're a victim of defamation, there are a lot of options available to you for relief. The first thing that usually comes to mind are monetary damages. In some cases, these can compensate for harm that's occurred. Monetary damages can come in a few forms, including actual losses for financial losses, presumed damages in cases of statements seen as inherently harmful, punitive damages where malice is clear, and the amount is not only to compensate you, but is intended to deter and punish the defendant and dissuade them from continuing to publish statements that are so intrinsically harmful. Injunctive relief is another remedy that involves requiring the removal of defamatory statements from various platforms. You can attempt to secure content removal through sending retraction demands or cease and desist letters, which request corrections to false publication. This can be seen as, your attempt to mitigate the ongoing harm without first resorting to the court. However, a cease and desist or a retraction demand, it's not a formal legal document, meaning it's not filed on the docket. The only way that you can try to enforce those demands is through filing in court and hoping that the court rules in your favor and grants an order in your favor, or you reach a private settlement agreement. It's important to remember that many platforms are increasingly reluctant to remove any sort of false statements, even with a court order, and there's really no way to hold platforms accountable for failing to remove statements adjudicated to be defamatory. There's something called Section 230 that pretty much insulates any platform from any sort of liability for content uploaded by a third party, meaning that Twitter does not have to remove statements published by a defendant, even if there's a court order saying that those are defamatory. Now, courts may also be reluctant to issue an injunction since it might be seen as a restraint on speech. They might view a more appropriate remedy as compensatory or monetary damages. Any part of this process that has the possibility of public should be evaluated as part of your attorney strategy. At Minc Law, we draft correspondences like demand letters and negotiations with publication of these letters as a real possibility. Any adverse party can publish anything that I send to them at any time. So we ensure that anything we draft paints you in a positive light and describes the wrongdoing accurately. We adjust our strategies to fit each unique case, keeping your reputation intact at every step of the way. Defamation cases can face a significant challenge, but armed with knowledge and the right support, you can begin to repair your reputation in the way that's best for you. I hope I helped you gain a better understanding of law and how to gather the evidence you'll need to build a strong case. At Minc Law, we're here to guide you through legal strategies to fight defamation and help you regain control of your online presence. If you're struggling with harmful content online, give us a call to speak with one of the members of our intake team, or visit our website, minclaw.com, to fill out our contact form or use our live chat. We'll help you sort out the details of your specific situation to start building a case, or we'll skip right away to analyzing all the meticulous evidence you have collected after watching this video. We're here to guide you through the next steps towards achieving your goals. I'm Sarah Kolick, an attorney at Minc Law. Thank you for watching and see you next time.